So I want to attach this video to the current Darwin Oak petition, Save Darwin Oak on change.org, which is to Shropshire Council. But this is also relevant for the Stonehenge Tunnel petition as well, and all building and planning objections and legal cases when it comes down to, like Gail Bradbrook and some of the Extinction Rebellion cases, and just the justice system in general, right? So I really need to make this video for Daniel Hedwin as well in the Judicial Conduct Investigation Office, because this is now what we're looking at. We're looking at the rights and the process of law and judgment in the courts and in the councils, in the local authorities, and what basically us, the public, the people, the peers, we are the peers and we get selected for the jury, but we are also the peers and we sign and support and give consent to petitions and the actions which petitions bring to government, right? You get decisions by judges, you get decisions by council chambers, and you get decisions by ministers in Parliament, right? But those decisions can be brought to referendum. They can be brought to referendum, or in a jury, you get randomly selected people, or when it comes to like Parliament, you can have the people. A referendum is overriding all of Parliament, all the elected ministers. But so this whole jury matter, the matter of the people, what is this power of the people, right? Well, it is here, right? It is lawful due process of judgment by your peers, a lawful judgment of your peers by a due legal process, a legitimate legal process, or by the law of the land. Well, that means that when you go to court and you have a jury, you've called everyone in. You've got the evidence, you've got a prosecutor, you've got a defence, you've got evidence, you've got facts. You are having a hearing. A hearing is a lawful judgment, a lawful process, because you've done it properly. It's official, so to say. It's an official lawful process. Now, the thing with doing a petition to the government is it is a legitimate lawful process. When you go about collecting the signatures from the public, from the peers, their opinion, and they sign, they're supporting it, and you're amounting signatures from the public, that is, particularly when you're getting tens of thousands or 100,000, when you are actually going about that, and you've got the document, you've drafted it, not only have you published it, for example, on change.org, or on 38 Degrees, or on HM Government Petitions website, or you've got the documents in paper form, and you've got those signatures on there. You've initiated and you're engaging in a lawful process, because it exists, that lawful, legitimate process, and you are doing it the lawful way, the proper way, right? Now, where we're running into problems, this is the 1628 Petition of Right. This is the 1628 Petition of Right on the Liberty Fund website. And here you can see I've typed in the word peers, and it only appears once in the entire document, right? And that's where it is there in orange. You can see it in orange. I typed in the word peers, and it appears there, right? And this is, under 3 there, look, 3. So we've got 1, 2, 3, and then V, and then VI, and then VII. Okay? Now this is really, really, really important now, because this is where we get in some corruption, lies from the government, from ministers, from the records, right? This writing here, this is the entire act complete, the original act. The original complete act here is complete, so we can see what it is meant to say and meant to have in it. Now, underneath 3, there, you will see IV. And it says, and in the 28th year of the reign of King Edward III, it was declared and enacted by authority of Parliament that no man of what estate or condition that he be should be put out of his lands or tenants, nor taken, nor imprisoned, nor disherited, nor put to death without being brought to answer by due process of law. So this is due process of law. So if it wasn't due process of law, it wouldn't be lawful process of law, right? But what is the due process of law, right? This clause here, IV. What is the due process of law? What is it? What is a due process of law? Right? Well, we know what it is because it tells you above. Right? Lawful judgment of his peers or by the law of the land. Lawful judgment of the peers, that is the jury, the people. But what would an unlawful judgment of the peers be? What would an unlawful judgment of the peers be? Well, it would be a judgment that hadn't been through due process of law. Like they all just went into the woods and got in a circle and hanged someone. Or they just, and not all the evidence was heard. Right? Because that's not fair, is it? It's not fair. Why do we have a due process of law? Is to make sure all the facts are heard, all of the evidence is given, and everyone has a right to speak. And that's the whole point of modern civilization. It's meant to be why we're civilized, right? So we do have laws. We have the law of the land, which is the legislation of the country. The legislation and law of the nation, right? But those laws are only applied by the judgment of your peers. And your peers actually can disregard the law if they don't think someone deserves to be punished or if they don't think that they are guilty, regardless of what the law says. By the lawful judgment of his peers or by the law of the land, or by the law of the land. So there's an absolute differentiation here between the judgment of what the peers think to what it says in the law. What the peers think to what is the law. Right? And this example is extrapolated or given in a very, very good working example in the case Ian Bray versus Crown at Southwark Crown Court with Judge Gregory Perrins. I don't need to give you any more information than that. We've also had a similar outcome recently with another Extinction Rebellion case by a jury as well. In fact, apparently 50% of the Extinction Rebellion cases that are heard by jury, 50% come out with not guilty verdicts, right? So that is the model of how this works. The judgment of the peers through a lawful process, due process of law, which means that they're in a court and all the evidence is heard, and you've got the right to a defence and so forth. It's not it's not like that the police didn't just take them into an alleyway and hold their own makeshift hearing and make things up. It's called due process of law. So even in due process of law, through a proper due process of law, when all facts are heard and everyone has a right to speak and have a defence and so forth, a proper lawful process, there is still the judgment of the peers, right, which doesn't have to agree with the laws of the land, the legislation, right? Because the peers can make up what the laws are. The peers can vote and elect the MPs to change the laws. Because if all of the people of the country want the laws changing or to scrap the laws, they can do that. Because the people have the right to get rid of the laws or change the laws. Now, why am I making this video this time? I've already talked about this before. And I've already submitted this 1628 petition of right evidence to the Judicial Conduct Investigations Office. Because some judges have been misleading juries into believing that they can only make a judgment by the law of the land. That a judgment can only be made by the law of the land, not by the judgment of the peers. The lawful judgment of the peers. How would there be an unlawful judgment of the peers? If it wasn't by the due process of law, if you weren't in court and you weren't having a hearing, if they were on an island somewhere and they just made it all up and it didn't have fairness because there wasn't a proper process in place, right? Now, I've pointed out this clause 3 here, and this clarifies a lot of things. It also would mean that not just in criminal cases and not just in civil cases. Remember that civil cases can have a jury, and traditionally they're really supposed to have a jury in a lot of instances, but they've kind of not bothered having them anymore, right? And that also comes down to political proceedings, like for Parliament or for local council, because we can have a referendum. Now, the referendum is the judgment of the peers. The peers get to decide matters of planning, land use, what things the council should and shouldn't be doing by referendum. Also, the judgment of the peers is what elects councillors and elects ministers. They've only been given the power of council or the power ministerial powers by being elected into place by the judgment of the peers. And by the way, that is the due process of law of election, where a proper process has been put in place and has followed to obtain the signatures, let people know there's an election going on and where and how to vote. Otherwise, it wouldn't be a due process of voting. Now, all this is basis, but it is all correct basis because we've got acts of law which this is based on. And this is where it comes from. If you couldn't have your judgment of peers, your peers wouldn't have the right to decide anything. They wouldn't have the right to decide who they're going to elect and so forth. but it's all by due process of law. So this IV here, right? This IV works because of the section above it, right? If you're having a due process of law, what is that due process of law? Well, you know what the due process of law is. It's a judge and jury. The due process of law is a judge and jury and proceedings using the legislation, right? So you can't have this, and it's not about anything else either. It's about people being punished for crimes and so forth, or civil suits when your lands are at risk, or tenants, or even being imprisoned or disinherited, or even death sentence, right? It's not about anything else other than legal process. This paragraph here is talking about and referencing to nothing other than legal process, right? Because of things that have happened, right? And these are things that even can happen now today, right? And what's this above it? Well, it's the exact same thing. It's been taken, imprisoned, dismissed of his fields and liberties or his customs, and outlawed or exiled in a manner but by lawful judgment of his peers. So what are both these? They're both only concerning, they're both explicitly and specifically concerning normal due legal process in England and what that is. They're not about anything else. And it is the fundamental basic legal process about the normal things that would concern. What does normal legal process concern? Freedoms, liberties and customs, which is like in the criminal procedure rules, overriding objectives, recognising the rights of the individual. So this is very simple, basic recognition of the very essence, the skeletal system. You go to a court, you have to put a skeleton argument down. This is saying that you have got the very basic fundamental rights of legal due process. And this as well. They're both saying the same thing, right? Lands, land ownership, tenants, whether you're imprisoned or not, and here about rights and liberties. So both these are still in use now in the manifestation of the criminal procedure rules and civil procedure rules. And that is fact. So now we come on to where the problem lies. Now here's the problem. This is the copy. This is the copy on the legislation.government website, the Petition of Right 1628. This is the copy that Parliament have published on their website, right? Here. And it is the same as this. It is the 1628 Petition of Right, and there is the writing of it. There is the original in the old handwriting text. So we know what it is. Now we've got a problem because this is very important here. The part in orange that I've highlighted in 3, right? That is critical. Why? Because this is what all our legal and due process is founded and based on. And that is that when you are entering a due process of law, which we've got, when it comes to judgment of the jury, there is the laws of the land are not the same as the opinion of the peers. The opinion of the peers does not have to be exactly the same as the law of the land, as long as it is all by due process, which means that you have got a jury, you have gone to the people, you have put the facts down, you have given people a right to speak, right? And you have set out the legislation and so forth, and it's all done professionally and properly. It's not a cheating system. It's not a couple of brigands in the woods who have just grabbed someone and they're going to chop the head off, and they don't let them speak properly, or they've made up an illegitimate process which is unfair, basically, right? But even by the due process of law, still, when all facts are heard and all evidence is put forward and everything is being done by proper due process of law, the peers can decide the opposite to what the legislation says, right? Now, this also, I believe, as it's the same foundational skeletal structure of what our entire legislation is based on, because this is the 1628 Petition of Right. And, what follows it is the tumultuous Petitioning Act 1661 and the 1688 Bill of Rights, as well as the Scottish version of the right to petition as well, the 1689 version, which says that no one can be imprisoned for petitioning activities. Now, this is now where we get to a very serious problem. And Parliament might have a very clear explanation for it. Parliament might have a very simple explanation for it. But here, let's keep this part here because we're looking at 3 and IV, right? So here, let's just check the top here. We're definitely on legislation.org. So, when we look for 3 here, right? And also, this is based on the Great Charter and Liberties of England, which was a major piece of legislation that all the rights and privileges were founded on, which states that all the laws that are written they're there for the people. The laws are there for the people to use and enforce themselves as well as be enforced on them. The laws aren't only there for the king or for the lords, they're there for everyone to make use of the laws. That's what the Great Charter and Liberties is for. Now, if you look here, 3 isn't there, right? It's not there. There is 3. There is the number 3. And here it's not there. Now, it tells us we can't even see the original. Now, what happens if you want to read what it was? What happens if you want to read that to know what it was? It says that sections 3 to 5 repealed by the Justices of the Peace Act 1968. But I don't know how you could repeal that, because there's nothing there that you would repeal. Because what you're claiming that you were repealing is the right to a due process of law. You would say that you would be repealing the due process of law. Why would you? This concerns nothing else. It doesn't concern anything other than anything that you would suffer legal consequence out of, like ownership of lands and things like that, can only be done by due process of law. Why would you repeal that? You can't do any of those things now without due process of law. So why would you repeal it? In fact, I doubt you could, because if you repealed that, you wouldn't have due process of law anymore. You wouldn't have due process of law because you would be removing it. So only a simpleton, only a fool would repeal it, because it can't be repealed, because you would be repealing the law itself. So it's stupid to repeal it. Right? Now, and the other thing is this. So VI is down there. That's VI there. So this is 3 IV and V supposed to be there. 3 IV and V. Claim that it's repealed. So it doesn't make sense. And the thing is, it doesn't matter if it's repealed or not, because the thing is, this tells you something very, very important. It's not a matter of it being repealed or not repealed, because we don't really need to know whether it's repealed or not repealed, because this isn't really a special provision or any common law or anything particular, like, you know, a certain act or a certain clause or a certain law. What is important about it is that it is the definition and the terminology, the descriptive clarification of what the law is or was known as, and what that due process consists of. And that due process consists of the judgment of the jury and by the law of the land, right? That helps us clarify what the law is, what it was created to mean, so we can understand, we know what it is, right? Now, the ironic thing about this is that was repealed in 1968. Now, you can't tell me that all through history, since 1628 till 1968, all through the 1800s, all through the 1900s, all through the 1920s, driving cars, smoking cigarettes, all through the 1930s, all through the 1940s, all through World War II, all through the Bauhaus in Germany, and then all through the early 60s with the Beatles, when it's a normal functioning country, and nation with courts. You know, God knows how many times the Beatles were in court before 1968. You know, all through Elvis, Marilyn Monroe, a working, functioning democracy. New York, Los Angeles, London, Scotland, Edinburgh. You can't tell me, right, that until 1968, this is what the foundation, a major structure of the entire legal due process and law of England is, and what the definition of it is understood as. You cannot tell me that the entire basis, the entire foundations and structure of what a jury is and its functions was suddenly repealed in 1968 of all times, when they've been using that process supposedly all through the 1920s, 30s and 40s and 50s and early 60s in their pop music cases. You're telling me that the entire function of a jury and structure of what it's meant to be and supposed to be was suddenly repealed? Well, that would... So, you're telling me they replaced the entire basis of the jury? I severely doubt it. I doubt it. I don't think they did. They didn't replace the jury. They didn't change the jury at all whatsoever, because you can't do, because they've still got it. Right? and this is not an act, and that they repealed that you had to be put through due process by law, so it's no longer a requirement to be put through by due process of law. That is, to make that claim, that's no longer in effect when there's nothing to repeal, because if you repealed that, you wouldn't have any laws. So this is performed by a simpleton. Now let's actually go and check this Justice of the Peace Act. Hold on a second. Right, so it's saying schedule, so this is it. Justices of the Peace Act, 1968. Right? And it says, I think it said Schedule, Section 5 and Schedule 2. Hold on. Schedule 5, Part 2. There's nothing there. Schedule 5, where is it? Right, we'll click on Original as enacted. Schedule 5, enactments repealed. Repeals of, reason given, unnecessary enactments. That's the reason given. Unnecessary. Repeals of unnecessary enactments. So this is with the habeas corpus Jurisdiction in Liberties Act 1535. The whole act so far is not otherwise repealed, but so that the repeal of Section 3 shall not affect the form to be taken by the process of any court. Well, that's interesting, because the form and process of courts is built on a just, fair system, a lawful due process with a jury there. Shall not affect the form to be taken by the process to any court. Well, we know what the form of the court are. It's to be the legislation or judgment of the peers. But here it says it's unnecessary. It's not saying that, we don't like the act anymore. It's just saying it's not needed. It's unnecessary. Well, a jury's necessary. A jury's necessary, or else you can't have a verdict if you don't have a jury. Do you know what it's necessary for? I'll tell you what it's necessary for. Clarification. Clarification. What is this object? I found an object dug in the ground, an ancient artifact. We don't know what it's for. We don't know what it was designed or made for. Is it a back scratcher? Is it a, cigarette lighter? No one knows. Well, why don't you have to go find a historian and find out what its purpose is for? There's a couple of people sat in a court here, a jury. Does anyone know what these people are here for? They're to make a decision. Based on what, though? Law. And what? Is there anything else that could clarify that for us, make it a bit more clear to what the intended purpose of this item or function was used for? Yes, let's just go look back so we can clarify on that. Is it necessary to clarify something? Is it necessary to establish how something worked, what its proper function is, how the function of it works? Or is it unnecessary? I think it's very necessary. Now, what did I say about those acts? They're not doing these two clauses. There is no special. This is pure. This is pure establishment of the simple legal process. This is the most simple confirmation of what the legal process is. There's nothing unique or different about it, other than the fact that we can be put to suffer legal consequence without due process of law. Why would that be unnecessary? These 1628 statutes make certain that we can't be suffering legal consequences, right, without due legal process, and someone didn't think that was necessary, Someone didn't think that this is needed. Someone didn't think that it's required. Someone think that it was unnecessary to make sure that legal due process of law had to be followed before he could face legal consequences. Who are these ministers? Who are these men and women who are being elected and put forward by political parties? From Newcastle upon Tyne, Tracy Brabin, Mayor of West Yorkshire, David Cameron from Chipping Norton, chipping a golf ball into an hole, hanging round with Nicola Brooke from The Sun, pop into Parliament, pop back out again. Oh, I'm off to Oxford to learn something. Now I'm going to tear a pub to pieces and not suffer any legal consequence because my peers aren't going to report it. In fact, my peers are protecting me. Now I'm a Lord of the Realm. Who in 1986, in their right mind, would deem that it wasn't necessary to have the main two clauses which made sure that you were put through due legal process and the skeletal structure of the very process of which you're turning up in court to answer to? Who would remove it? Or would you move the jury from due legal process? You would have to be a simpleton. And no other reason is given because it's unnecessary. The entire jury process, not part of it, all of it. None of it. Or you can't even be judged by the law of the land anymore. Who is electing these people in 1968 while the Beatles are singing Love, Love Me Do? Norwegian Wood. It's been a hard day's night. I've been working like a log. There's some pimpleton in Parliament repealing this. Repealing the requirement to be put through due legal process of law. Are these people insane? Are they fit for purpose? Are they fit to be elected MPs in a parliamentary position? Are they fit to be in the House of Lords? This is crime. This is criminal. This is a criminal act. This cannot be repealed because you wouldn't have a due process of law remaining. And it's not the fact that the entire legislation of England is built up on the structure. This clarifies what that structure is and where it came from, so we know what it is. So you didn't get a back scratcher and end up wiping your bottom with it because someone forgot it was for wiping bottoms and they thought it was for back scratching. Because this tells you what the purpose is, what it is and what it is for. So it cannot be repealed. Now here, if you scroll down, right, we've got the petition of right here. And it says 3. It doesn't actually say, it says 3. The petition of right, sections 3 to 5, and in section 8, the words from and that no to detained. So it's not really, there's not really any proper reason given, any specific reason. They claim that it's unnecessary because there's sufficient law and legislation in place where it's not needed. Probably because there's other acts that say that, you know, you got to go by through legal due process. It's not actually said that they're changing the function of the jury. It would suggest that the function of the jury is already known and established and in place. So I don't believe that those could be repealed anyway, because that's foundational law. We've also got some habeas corpus and Great Seal Act stuff here. An act to provide for more effectual execution of the office of the Justice of the Peace within the parish of Merthyr Tydfil. Indictable Offences Act. Offences against the person, Admiralty. Local Government Act. Some of these are actually very interesting to read. Local Government Act 1888. Only section 78, but from but onwards. The Justices of the Peace Act. These are actually all be interesting to study. This is a good list of acts to actually read. Another Justices of the Peace Act. Magistrates Court Act 1952. Public Authorities. Administration of Justice. The Criminal Law Act 1967. Section 4. Well, luckily... Section 7, Part 4. Section 7, Part 4. Luckily, Section 4 is still in effect then. It's not been repealed by this. There were actually Oxford University Justices Act. That Local Government Act 1888 seems very interesting. Malicious damage. The Great Seal Act. So Great Seal Act 1688, Section 3. Habeas Corpus 1640, only Section 6. So the Petition of Right. Oh yeah, Section 3 to 5. We said that. The Jurisdiction and Liberties Act 1535. Well, that would be interesting to read that. The Jurisdiction of Liberties Act 1535. I haven't read any 1535 acts, but only Section 19 so far as unrepealed. Hold on. Right, so this Jurisdiction and Liberties Act 1535. Wow, this is really interesting because this is like right in the medieval period, isn't it? Still, this is before